Vision, you ready? Okay. We're on the record. This is the formal hearing of the Utah Board of Oil, Gas, and Mining on Wednesday, March 28th, 2018. Our first agenda item is docket number 2018-002, cause number 210-06, regarding the State of Utah School and Institutional Trust Lands Administration and Enduring Resources and Westar Exploration. That matter has been continued until the regularly scheduled April hearing of this board. The second agenda item is docket number 2018-003, cause number 139-153, in the matter of Axia Energy 2. Bear with me for a second. Okay, at this time, we will take appearances of counsel.
David Bolda with Beatty and Wozniak on behalf of Axia Energy 2 LLC.
Meg Oswald with the Attorney General's Office for the Utah Division of Oil, Gas, and Mining.
Any other counsel? Seeing none, then how we'd like to proceed is to address the division's memo, and then I think we're going to have a break for the board to discuss that, and then we'll come back for your case in chief. Is that an acceptable
Yes.
process or procedure?
Sure.
Does anyone feel like that puts them in any jeopardy or a problem? Mr. Bolda.
No, I can discuss it to the extent that I can state my objections and also state that
Yes, we want all of that.
Okay.
And then, Ms. Oswald, is that a procedure that you?
Sure, yes.
Okay, we'll do that then. So, if that's the case, then I think what we'll do is it's appropriate to go to the division first, and then come back to you, Mr. Bolda, for objections, if that's.
Yeah.
Okay, division, we'll go to you first.
So we realize that it was submitted late and do apologize for that. The intent,
Late by was yesterday?
yes.
Okay,
So,
just so the record shows
yes,
what that
it
was.
was yesterday afternoon, and board secretary was out, so I think it got to the board late yesterday afternoon, and it got to opposing counsel sort of earlier in the day yesterday afternoon. And the intent of this memo is just to bring an issue to the board's attention as to some language that's been used often in board orders and has come up to the division as far as APDs and whether or not they should be issued. And you know, basically what the division has come to realize is that the language isn't clear on what would be required for an APD as far as consent for an off drilling unit surface location. So the division just with this memo wanted to bring that to the board's attention, that this particular language that has been used in requests and is proposed in this particular request we don't know what it means. It's not clear, and it's, you know, maybe even misleading. And we just wanted to bring that to the board's attention. Again, we apologize that it was late, but that was the intent behind submitting that.
Why don't you make sure the board, since it was filed late, what the give us the essence of what that memorandum was meant to accomplish.
So I'm going to try to do that and be short because I don't want to step on opposing counsel's toes as far as what he may object to coming to the board's attention. I don't want to, overshoot that, but essentially the language is proper authorization for such a location as required by law. And that is with respect to off-drilling unit surface locations. So the language says authorization for the location as required by law. It doesn't say what is actually required by law. And the division then doesn't know that, and the operators with respect to that are supposed to provide a self-certification that they have this proper authorization as required by law. And so, when an operator provides an APD, an application, they self-certify, we have the proper consent or authorization as required by law to do this off-drilling unit surface location. And we don't, because it just says as required by law, the division doesn't know actually what proper consent they are self-certifying that they have. Are they self-certifying that they have permission from the surface owner at that off-drilling unit location? Are they self-certifying that they have permission from the mineral owner? Are they self-certifying that they don't need permission? We as the division don't know. So the intent of the memo was just to bring that to the board's attention, that this particular language being used in this RAA as it's proposed is unclear to us. Does that answer what you were?
I think I understand it. Board members, do you think you understand what that means? Anything else you'd like to add, division?
Yeah, I'm trying not to, again, say too much. I don't want to step on opposing counsel's toes, as I know they probably haven't had sufficient time to prepare to address this issue. I'll just say, it's coming up probably more and more often, despite that it has been used regularly in the board's orders in the past. I think, the off-drilling unit surface locations are becoming more common, and it's a conflict now that we're dealing with, and I don't want to get into that particular conflict here today because one of the operators in that particular conflict isn't able to weigh in. So we want to stay away from that. But essentially it's come up because of a conflict. That's how it got brought to our attention, and that's our motivation for bringing it to the board's attention today.
All right, are you concluded?
I think so, sure.
Okay, Mr. Bolda.
Thank you, Mr. Chairman. So I first need to state that I have a conflict in this issue, and I can't get into the weeds, so to speak, on the details and the law relating to this, other than to say that the request and the language in the request has been used many times, and I agree with Ms. Oswald's statement that off-site drilling for these long lateral horizontal wells is becoming more common. And it's because the nature of that issue, and in order to capture all those resources. But I don't think a conflict between operators relating to the off-site drilling units is a major issue or is becoming more prevalent. I also want to state that the language that's proposed and the board's continuing jurisdiction, allows the board to come back if a better language, after it's been fully briefed by all the parties that would be interested in, if better language is developed, or the board wants these to head in a different direction, the board can come back. We can amend those orders as it relates to that language. Also, on any of these offsite drilling locations, there has to be a surface use agreement, so that's always in place, and the operators get surface use agreements for that drill site where the well pads are located. Again, my other objection, and of course has been noted by others. That's the timing. The timing. It just didn't allow the parties sufficient notice what the division would be requesting of the board. We were unable to prepare. Again, even if I had notice, I don't know that I would have addressed it any differently because of a conflict issue. But I can tell you that the other operators that would be involved in this this issue and have an interest in how this language is how it's stated in these orders would all want input and would I think have an issue with the timing of this memo and not being able to have input. And I believe that we can move forward on this request with the language that's in there that states that we'll self-certify that we have complied with the law, that Axia will self-certify that they're in compliance with the law is sufficient at this point to move forward, and that the request can still be approved. And then again, with the continuing jurisdiction, if something needs to change, that can be addressed down the road through an amendment.
All right, I have before we're going to go in and discuss this. Mr. Rogers, I have a question for you, if that'd be all right. One of the concerns the division has mentioned previously is the flood of APDs. Some will be drilled, some are just for protecting the first in time, get at the head of the line. As you see this, would this be the possibility of bundling both of those issues into a discussion by the board, or do you see those as being separate?
I think they're two separate issues. I think the rash of APDs is to try to establish a position in each individual drilling unit, whereas the off-site location is the issue of real drilling through other people's land. And does the surface owner and does the mineral owner need to be noticed who, what, and where, and how much they need? What does required by law mean? So I think those are two separate issues.
Okay, I think we're going to look at the issue of operatorship and how that happens and the conflict. So we'd like to have that discussion with you offline at a later time. Thank you. Okay, board members, we're going to go in and I have a hand in the back. Come up to the microphone. Please identify yourself, who you represent, and the address, please. And speak closely to the mic.
Yes, sir. Katie Booker with the BLM in Vernal, 170.
BLM Vernal is a nice address.
Okay. I just wanted to mention that, and this is not really my area of expertise, but the BLM has some requirements for off-site measurement also. Or we have requirements about off-site locations, so that you're off the lease and some measurements, but it's not my area of expertise, so I know that the BLM would want to check in on this also.
Oh, that's good to know. Thank you. We didn't, I think that'll help the discussion.
Okay.
Thank you. We're going to take a break for a few minutes to discuss this. I think if this room's available, Mike, will we use that one? Otherwise, we'll go into the other conference room.
I don't see those as two separate issues.
Well, I think
Well, they can do it at the same time, but I don't think your rash APDs have
make it more complicated. It used to be messed up.
What?
Steve didn't want it, so his comments just have to do with it.
You can't hold it there. These guys hold it. I told many guys, like, Steve, that's 3 hearings in a row. And it's not like you're an elder. So they're aware that it's been a problem, but they just don't address it. So we put in a memo. The memo is in a form where they can digest it.
So you're
I don't know why.
to approve it, we're not go through those. So don't like.
That's what I want. I'm not saying they have to do anything about it. Just stop putting in the ordinance if they're doing something that doesn't mean it.
Well, yeah,
Just say,
the thing is they're saying required by law. Everybody's saying,
that's
well, I'm not making that certification, but there's nothing required by law.
that's
So
okay,
it's like,
then let's not put it in.
it's like you're playing a game.
Just put in the order that if
Someone
anybody objects, they can.
invented that phrase years ago.
Yeah, I don't care how it comes out. It's just like,
Really
Just spring it on us at the hearing, make it even better. Or just don't comment at all.
Well, the point needs to be addressed, whether it's today or another
I
time.
agree. I mean, I understand.
You're in a real difficult predicament.
Yes.
We don't know what that means.
I understand, but you know what? But I think it actually offers. They're saying, okay, we rely on their statement. The order says, here's our opinion. So they complied with the order.
And if they're in it, so we got something different. Now we're dealing with it.
But I think.
So when you write that, when they're doing a permit, and you say, do you notify people, or what is the problem? In your mind, it's required by law.
I can't talk about.
But what, all these attorneys, when they say self-certified, they're doing something. What is that? What you do may be different
Okay,
than
so-
what another person does, and what another person
It's a legal opinion, we don't need to do anything.
Yeah. Well, that is required by from advice
self-certification
from their
is a vague
counsel.
term. And we don't know what it means.
Well,
I don't know if we.
There's something here that we did start it, I know, Autumn, it finds out where the problem is, the GPS, or the survey. And we're actually plotting those. They're kind of easy. They take two, the software we've got, it takes all day to do two. But what we could do, because the landowners are gonna keep saying, surface location is here, where is the well? Everybody understands
Okay. Have we got we're okay on that end? Michelle, you ready to go? Okay. We're back on the record. The board has reviewed this matter, and we have two parts of this that we're going to tell you. Part number one is, as to the division's brief, we will not be considering that as part of this hearing. As to the issue in general, we have instructed our counsel to open up a docket to address this issue in a programmatic manner that would affect all of the pilot projects and the future of where we're going. We would probably do that in the form of a docket opening up proposed rulemaking so that we can get the publication notice and get all the parties here that we can. And the reason for that is we want this, we've got to get an order out, and we're not going to hold it for months while we and do this. But we do want to solve the division's concerns. We want to address them and make sure that we get right on them. And so to the extent, division, that you can help frame how that docket is worded, we would appreciate that. Okay. With that, then, we'll go back to you, Mr. Bolda, for your case in chief.
Okay, thank you, Mr. Chairman. I'd like to introduce my witnesses at this time and ask that they be sworn in. Is that okay?
Yeah, proceed.
Okay. To my left, I have Rick Gallegos, Vice President of Land and Business Development for Axia. On the row behind us, Adam Sayers, President and Founder, and David Schmude, Vice President of Geology. Like I said, I'd like to ask that they be sworn in at this time.
Okay. We're not going to hear from, who's your engineering witness?
Adam Sayers will be. Taryn Frenzel is not here.
Okay. So we're not going to have Taryn or Brian?
Correct.
Today. Okay. Thank you. Okay, if we'll have those witnesses sworn in. And division, do you have any witnesses that you'll need to have sworn in at this time? Okay. Then, court reporter, if you'll proceed.
Will you raise your right hand? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. As has been the previous practice of the board, I'd just like to confirm that it's acceptable to move for admission of all the exhibits at the end of the presentation.
That is our preference.
Thank you. I'll now give a summary of the case before we get to witness testimony, and I'll be brief. That the subject lands are located in Duchesne County. The majority of the lands are just north and adjacent to Axia's previously approved spacing orders and cause number 139-40. That's where the majority of the lands are located. There's also some near some of Axia's other spacing orders, and primarily in 139-138. Many of the exhibits and testimony that will be presented today, the board and the division has seen before. These will be very similar. But Axia is requesting that the board approve Axia's request to create 20 1,280-acre overlapping spacing units. And these will be comprised of the lands that will be discussed by Mr. Gallegos. Notice of the request and this hearing was sent via U.S. mail to all owners in the area where spacing is sought and to all administrative agencies having jurisdiction over lands in which the spacing is requested. All such mailings were mailed to the last addresses disclosed by the relevant federal, state, and Duchesne County Realty records and by Axia's internal records. There are a number of parties whose last addresses disclosed by the relevant records were undeliverable or returned. However, notice was published in the Salt Lake Tribune and the Deseret News on March 4th, 2018, and the Uinta Basin Standard on March 6th, 2018. As to the responses, there was one anonymous response received from affected surface and royalty owners that was filed on March 15th. As we've already discussed, the division filed a staff memorandum yesterday. No other responses to the request were filed. I apologize. The BLM did submit a letter offering their approval for Axia's request on behalf of the BLM and the BIA, stating that the BIA didn't voice any objections to the BLM. Other than that, there were no other responses. I would also like to point out at this time, in the caption on the original request, there was a mistake just in the caption portion on the first page. It listed that the lands involved were comprised of sections 4 through 9, and then listed some other sections in Township 2 South, Range 2 West. That was corrected in subsequent filings. It should actually be 3 through 10. So on all the other filings, the exhibits, the certificate of service, they all list 3 through 10. And in the body of the request, we had listed 3 through 10. It was just a mistake on that original caption, which has since been corrected. Okay, we'll now go to my first witness, Mr. Rick Gallegos. And he'll be testifying as a fact witness. Can you please state your name and business address for the record?
Yes, Rick Gallegos, 1805 Shea Center Drive, Highlands Ranch, Colorado, 80129.
And your current position with Axia?
I am the Vice President of Land, and I oversee all land operations for Axia.
Okay. Can you please state the Axia's corporate and bonding status?
Sure. Axia is a Delaware LLC, qualified to do business in Utah, and also bonded with all of the relevant governmental agencies.
Okay, thank you. I'll point out here Exhibit A, that gives the qualifications of the witnesses that are here today. Exhibit B lists the copies of the prior orders, which we won't discuss in our testimony. Okay, Mr. Gallegos, at this time, I'd like you to please turn to Exhibit C, D, E, and F, and I will ask you if these were prepared by Axia personnel with your input and review.
Yes.
Thank you. All right, turning now to Exhibit C, can you please explain this exhibit?
Yeah, Exhibit C just depicts the lands where they're located within the state of Utah, the lands that are of the subject today.
Okay. And they are on the border between, right by, in Duchesne County, but near the border. Now Exhibit D, can you please explain this exhibit?
Exhibit D depicts all of the units that we are trying to space, all 20 units. And as you will note in this application, the majority of them are going to be lay-down units that provide for the drilling of east-west horizontal units. As we get to the east, we have some stand-up units that changes, and we do have some stand-up involved here. The majority of the lands here are already held by production, by vertical production. So there's a few units there that are not, that we intend on drilling here soon. The one thing I want to bring to your attention is on sections 18 and 19 of 2 South, 2 West. That is now going to be a stand-up unit.
Yeah, okay, thank you.
Our earlier spacing order, cause number 139-149, section 13, 2 South, 3 West, and section 14, 2 South, 2 West, and that one was a lay down unit. So we are changing that from a lay down unit with a portion of that to a stand up unit. And part of the issue is here is we do not want to strand section 19 and 2 south, 2 west. In regards to the geological makeup of that is kind of right on the border between what would be a stand-up and lay down, the way we look at that, and that'll be addressed later in the presentation. I also wanted to point out that all of those vertical wells will remain on 640-acre spacing, and production will continue to be allocated on a 640-acre basis, as well as any new vertical wells that we would drill. We would allocate production on a 640-acre basis. The long lateral horizontal wells will be spaced 1280, and production will be allocated on a 1,280-acre basis.
Thank you. Now to Exhibit E.
Exhibit E shows all of the existing spacing units, where they lie in relation to our new unit, which is in yellow on our new application. And then I'll also point out down south, cause number 13950, that's Newfield's application that was recently approved. So, and that provides for 24 1,280-acre units down south. In addition to what you see on this map, all the existing spacing units, Crescent Point has filed an application, I believe the hearing is next month, for 1,280-acre spacing units that will be in 2 south, 2 west, 2 south, 1 west, and 2 south, 1 east.
Okay, thank you. Turning now to Exhibit F, can you please explain this exhibit?
Sure. The yellow depicts the application lands. The red outlined area, that is just the notification area for those parties that will be encroached upon by this application. And then the blue is previously approved setbacks, and those lands will not be encroached upon by this application, so those folks did not receive notification. But those in the red outline did.
Along with all the people in the yellow, correct?
That is correct.
Okay. And can you explain the makeup of the mineral ownership within the application lands?
Yeah, the makeup, or I guess how our address list was compiled, was through a. The mineral ownership. Yeah, it's made up primarily of fee ownership, but there are some state, BLM, and tribal lands within that area.
Okay, at this time, I'd now like to show you the certificate of service. This is a pleading already on file. We're not using it as an exhibit. But I want to ask you, Rick, do you recognize this list?
Yes, I do.
Okay, and who are those, the names on the list?
Those are the names and addresses that we came up with through a search of the county records, through title opinions as well, and also through ownership decks.
Okay, and these would be considered business records of Axia?
Yes.
Okay. Thank you. Okay. Now, because I have Mr. Gallegos up here as a witness, address the letter that was sent by some anonymous affected surface and mineral owners. Because it was anonymous, I don't know that anybody here is going to testify or speak to that letter, and so I did want to address that for the board so we can share our response to the 2 recommendations that were included in that letter. The recommendation number 1 was that Axia be allowed to drill no more than 1 well in each 1,280-acre drilling unit before being allowed to drill a second in any given 1,280-acre unit. Mr. Gallegos, can you please respond to that recommendation?
Yeah, it really it would not be an efficient way of developing it. This would result in a lot of different rig moves that would be unnecessary, which would result in a lot of truck traffic on the roads. There are cases, and we've done it already, where we've went on a pad and we've drilled within the same 1280 2 wells already, testing 2 different zones. So for us to have to move the rig every time we drill and not be able to park a rig in a section and drill up different zones and test different zones, it's just not cost efficient.
Okay.
And it's just not commercially reasonable.
And it wouldn't allow Axia to drill and develop these lands as it sees fit according to its drilling plans and what it discovers throughout, correct?
That is correct.
Okay. And
furthermore, we may not ultimately, our intent is, and so far we've had the results that would guide us to this, but we may not end up drilling every single of those sections based on results. So it just doesn't make sense.
And the second recommendation in that letter was had to do with presenting a master plan to the board for approval with the first well drilled in each 1280, asking that this plan define drilling locations, pad sizes, right-of-ways, along with evidence that they have negotiated agreements, surface use agreements with all the affected owners. Can you please respond to that recommendation?
Sure. Well, when we submit a permit, we have to have evidence of having a surface use agreement at the time we submit a permit to drill, or that we've certainly made a good faith effort to get one and could not come to a resolution. So in essence, that's already done. The other thing I would say is that results dictate development, and we don't know at this point exactly what, with a 32 well program in a section, what's going to happen till we start drilling. I mean, it's not like you're doing a housing development and you understand what that is. We learn as we drill.
Sure.
So.
And so, as you stated, this is merely the first step in the process. Additional development plans come at the time you're getting ready to drill, correct?
Correct.
Yeah. Okay, thank you. Mr. Chairman, this concludes my examination of Mr. Gallegos.
Okay, thank you. Division?
Sure, I just have a couple things. I don't know if this is the appropriate time at all. I do think that, well, Mr. Bolda said in his opening that there were no other response. I know he had a public commenter, and I don't think the division would just kind of like to provide some clarity with respect to some of those comments. I don't know if that would be appropriate when Mr. Gallegos is here in case he has something he wants to say, or if it would be best saved to the end.
I think we'd like to link as many of these issues together as they're presented, so why don't you go ahead now?
Sure. So, yes, we didn't receive written response, but we had the public comment at the beginning just about, you know, overall notice and who's getting notice, and I think the division just would like to clarify, and the board likely knows this, but perhaps the public doesn't, that all of the division's title information comes from the operators. We don't have a title expert on staff. So I think that public comment was sort of, you know, you asked the division to maybe follow up on that and, you know, maybe provide a written response to what's gone on or why that notice may have happened the way that it did, or whether the proper people were notified. And all of our title information, unless the division is to staff a title expert, all of our title information comes from operators. So I just wanted to provide a little, you know, follow-up clarification on that, and we could answer questions on that too if the board had questions.
We'll save the questions on that till you're part of the presentation, but thank you for linking those.
Sure. Okay, so I just had one sort of overview question for Mr. Gallegos. You said that results dictate development, and I guess this is an issue that's come up a bunch in these hearings, and that is, if results dictate development, then why are Axia's requests consistently, and including this one, spacing just such big areas that aren't going to be developed for a really long time, and spacing them a certain way for certain types of wells if you know, we're not exactly sure.
Yeah, I guess I wouldn't agree with that statement that they won't be developed. If you look at what we've done and what we've spaced so far, we have gone out and we've drilled most of what we've spaced. If you look at 139, 140, we've drilled almost every 1280 on that. We just got approval for 139, 149, and we got that a couple of weeks ago, and we started drilling on that last week. So we are out there performing on these applications.
Sure, I'm not saying they won't be developed at all. I guess my question was the number of wells that are being approved in these spacing matters will take a significant amount of time to actually drill all of these wells, correct?
I would say
not to drill at all on the spaced area, but I mean, Axia has how many rigs?
Currently, we have one rig running.
Right.
But look at historically what we've done. We have got out there and we've developed what we've spaced.
Sure. I think I'm just more getting at the general size of the area, and it's not an objection, just a curiosity as far as.
And I would point to, you've just approved one for Newfield with 24 1,280 acre units. This is 20 1,280 acre, or 20 1,280 acre units.
Right, and we asked them the same question. So it's just a question, just a curiosity about the size of these areas.
I will say this too, it's much more efficient to come here and space a bigger area because you've got to do all the title and everything else than to be doing it a unit at a time or in small increments.
Okay, thank you.
Hey, we're to the board members. Any questions? We'll start on the right. Mr. Moon.
Yes. Exhibit E is a really good summary of all the spacing units that we've approved and that are proposed. Of those, weren't some of the earlier ones the conversion idea? Which ones are conversion and which ones are overlapping?
Yes, I can address ours.
Yeah, just yours.
Okay, as I address ours, 139, 138, 139, 140, and 139, 43 were conversion. And when I say conversion, in that case, the existing wells remained on 640 acres, but any new vertical or short lateral horizontal would be converted to 1280s. And then number 139, 149, and our current one, the verticals will remain on 640, existing and future drilled verticals and short lateral horizontal wells.
Okay.
Is the board clear on what that means, the definition as that applies? Okay.
And those initial three that are the conversion, where existing stay on 640, but future vertical wells go to 1280. That's consistent with Newfield's 139, 134. Is that correct?
I believe it is. I can't tell you exactly, but I think it is. Yeah, that's.
Okay. Just curious.
Yeah.
Yeah, on this side, any questions on this side? I just have one question for you, and it, I think well, it's actually a statement. Let me make a statement. I don't think any of us anticipated that these wells would come in as big as they have. And I don't know if we can get into the record, but there's only one real market for this, current market for this crude, and that's the Salt Lake refineries. And I just have understood that the Salt Lake refineries are near capacity. And so there are market factors that go into the drilling decision of where you can take it, in addition to capital restraints and other things. Would you respond to that, or would you like to have Mr. Sayers respond to that?
Yeah, Mr. Sayers has been working on that issue, so I will let him respond to that.
Okay. With that, then, would you please call your next witness?
Yes. Okay. Well, now you'll hear testimony from Dave Schmude. He has previously been qualified as an expert in geology and a number of matters before the board. I believe the most recent one was in 139-149. I'd like to request that he be qualified as an expert in geology for purposes of this cause, if that's acceptable.
No objection.
Board members, any objections? Seeing none, he is so accepted for the purposes of this hearing in geology.
Thank you. Can you please state your name and business address for the record?
Yes, David Schmude, 1805 Shea Center Drive, Suite 400, Highlands Ranch, Colorado, 80129.
And your current position with Axia?
Vice President of Geology.
Okay. We'll now show you exhibits G, H, I, and J, and I will ask if these were prepared by you or by Axia personnel with your input and review.
Yes, they were.
Thank you. Exhibit G, can you please explain this exhibit?
Sure. Exhibit G shows the application lands in reference to two well bores that strand across the area, shown on the left in cross-section view, and also shows the proposed horizontal spacing interval from the base of the Mahogany down to the top of the North Horn Formation as seen in both of those two wells.
Okay, Exhibit H.
Exhibit H is a closer view with the type log on the right showing our different frag zones or targets, so be it horizontally. We've identified a number of targets. Shown in green are our 6 primary targets. We at least have one wellbore, horizontal wellbore, in each of those 6 targets currently, and are contemplating actually the Wasatch 3 and the Garden Gulch as additional tests. So a number of different intervals that we're targeting horizontally within the project area, just showing a closer view of those frac zone intervals and the names we give them.
Pardon me, we're having a technical difficulty. I listened to the dialogue, so I know it's being received in the recording, all of these recording, and my unit just died.
Okay.
Battery issues here, so we'll just pause for 1 second.
We're happy to pause.
Just test your mic for a minute.
Testing.
Perfect. We're back alive, so let's keep going.
Very good. We just finished up with Exhibit H. We will turn now to Exhibit I. Can you please explain this exhibit?
Sure. Exhibit I is a cross-section showing the application interval and the individual stratigraphic units within that interval and their continuity across the application lands, so that all of the horizons are continuous across the application lands.
And the final exhibit, Exhibit J.
Sure. Exhibit J, which we've shown the board before, shows the petrophysical model example from one of our frac zones. As I alluded to earlier, we have multiple different frac zones, most of which are about 300 feet in thickness. This is the Uteland Butte frac zone, for example, and showing our petrophysical model. With our petrophysical model, we're able to calibrate porosity and saturation across the project area when we tie the petrophysical data to rock data that we've obtained. And shown to the right is the map of the petrophysical data set, or the modeled wells. So all the wells with the circles highlighted are wells that have enough log data to propagate our model to. So we have good control across the application lands and beyond as far as the resource in place models that we'll be talking about going forward.
Okay, thank you. In your expert opinion, then will a long lateral horizontal drilling program within the subject lands result in greater resource recovery and less waste?
Most definitely.
Okay, thank you. This concludes my examination of Mr. Schmude.
Thank you. Division?
No questions for this witness.
Board members? No questions? Thank you. Call your next witness.
Mr. Adam Sayers. While he's getting set up, Mr. Sayers has testified before the board many times. He is not only the president and founder of Axia, he's also an engineer, and he's been previously recognized as an expert in petroleum engineering and prior spacing requests. The last one was on docket 2017-024, cause number 139-149, and I would like to ask that he be qualified as an expert in this hearing.
Division?
No objection.
Board members? Thank you. Proceed. You're so admitted for the purposes of this hearing as a petroleum engineer.
Thank you. Can you please state your name and business address for the record?
Adam Sayers, 1805 Shea Center Drive, Suite 400, Highlands Ranch, Colorado, 80129.
And your current position with Axia?
President.
Thank you. I'll now show you exhibits K through O, K, L, M, N, and O, and ask if these were prepared by you or Axia personnel with your input and review.
They were.
All right, turning now to Exhibit K. Can you please explain this exhibit?
Sure. Exhibit K we've shown before. This is really an assessment of how much oil is in place and really establishes our different drilling targets. And so you can see in that upper table we have 6 individual targets, of which to date we've drilled all 6. They're in various stages of flowing back right now. But let's review the Uteland Butte, for instance. We'll do a line item through that table to establish the amount of oil in place in that particular target. But you have the Uteland Butte has 290 feet of net pay. Average porosity across that interval is 6.7% porosity. B sub O of 1.4, that's the formation volume factor. It tells you how much surface barrels you have as compared to a reservoir barrel of oil. S sub O is your oil saturation, which is right at 80%. And the area, of course, that we're looking at is 1,280 acres. So within that 1,280 acres, we have 112 million barrels of oil in place. We use a recovery factor of 10%, just based on experience in the basin and other reports. This would be on the conservative side, but believe that's a good number to use. And we also believe we have 8 wells to drill across each 1280 within each interval. That results in a recoverable reserve number of about 1.4 million barrels for the Uteland Butte in particular. And we'll go through the economics there, but I tell you, we've got 3 Uteland Butte wells that are online, and they're exceeding that expectation right now. But when we look at the economic parameters, we evaluated this from an April 1st start date in 2018. Decline profile B factor of 1.66 with an initial decline of 76%. The decline profile is built upon reviewing hundreds of wells within the basin. An initial GOR, which is the gas-oil ratio of 750 SCF per barrel. It does rise to 1,000. Then our NGL liquids of 54 barrels per million cubic feet of gas. We ran an average net revenue interest at 82%, paid normal fee royalties and severance taxes. We used a February 2018 NYMEX price deck that you can see below, less contractual deducts. We ran a CapEx, which would be our capital cost to drill and complete the well, of just under $10 million. And if we go back to the Uteland Butte well using all those assumptions, we come up with 116% rate of return. You can see all 6 of those targets. Our expectations range from 31% to a high of 169% rate of return. From an ROI standpoint, we see anywhere from, on an undiscounted basis, 3.5 to upwards of 5 on a return on investment, undiscounted, of course.
Okay, thank you. Moving on to Exhibit L, can you please explain this exhibit?
Sure. Exhibit L is really a cross-section looking at the 1280 and how we'll develop it from each particular zone and how we actually stagger these wells. We believe to date, just based on the volumetrics and well performance, that spacing will be 660 feet. In other words, the distance between wells in the same zone will be that 660 feet. So stagger pattern is used extensively across the United States in different plays. We believe it applies here. What we'll do is when you look at this pattern, the zone directly above or below will be staggered by 330 feet. And what this does is it minimizes the hydraulic interference between any of these formation intervals. And as approved in our previous dockets, we won't be closer than 330 feet laterally within the same zone from a producing interval or any existing future vertical or horizontal well. The stacked laterals, when they're in a different target or different zone, they will be at least 100 feet in vertical distance away, and there won't be any interwell setback laterally from wells in different zones. So you can see from the diagram below, this is again the cross section of what we anticipate full development to be. You can see that the distance between the wells in each particular zone is 660 feet. The shaded areas represent a 660-foot setback from the section line. And so those wells that are impacted by that shaded area, we will have to come back and ask for a waiver on those wells or adjust our rules to get those wells drilled to fully develop the section, which we anticipate doing once we go into full development mode.
Exhibit M.
Exhibit M is an illustration of the application lands as it relates to the principal horizontal stress and hydraulic fracture orientation. We have 4 different sources for this information. It's multiple image log data, which is FMIs, which looks at open fractures when we drill the wells vertically. We look at published image log data, microseismic data, and natural fracture orientation. And so when you look at this, we have a really good data set to help determine if these units should be laid down or stand up. And what you need to take away from here is when you drill any sort of horizontal well, you want the fractures to grow perpendicular to the wellbore. That will result in the best results. And so in this particular application, you will see that the lands are predominantly lay down. We've illustrated only the 4 1280s that we are asking for stand up. And when you see that line that goes at a 45-degree line through there, it's basically telling us that those could actually be lay down or stand up when that line kind of goes through there. But we feel the best results will end up being stand up in those particular cases, and the rest, obviously, the stress rotates as you get west, and so that means that we want to drill in an east-west direction, therefore propagating those fractures in a north-south direction. In the majority of the lands, you can see that the average across the lands is 20 degrees west of north. So that means that the fractures will grow in that direction, which is just in a slightly northwest southeast direction.
Okay, turning now to Exhibit N. Can you please explain what this exhibit shows?
Yeah, this is an illustration of the setbacks that we're asking for as it relates to the stand-up. So you can see our well bore will drill in a north-south orientation, approximately 2 miles. And this shows the setbacks that are currently in place, the 660 and the east-west setback. In a north-south direction, we're asking for the 330 setbacks. This is consistent. The 330 is consistent with our previous orders. And we used 45 degrees in the stand-up because that's our average fracture orientation for these particular, these 4 units. And that fracture will propagate again in a northwest-southeast direction at a 45 degrees west of north. Based on all the microseismic data that we have and the frac geometry that we model, we anticipate a fracture half-length of 311 feet. From an effective standpoint, it will grow in a north-south direction 220 feet and 220 feet in an east-west direction along that north 45 degrees west. And so we will still maintain separation from that north-south line and have 110 feet from the fracture to the section line. And again, no change on the east-west setback of 660. Again, as I mentioned in the staggered pattern slide, we'll have to come back to ask for permission to drill wells within those setbacks, which we anticipate in the future.
And now Exhibit O. Can you please explain this exhibit?
Yeah, Exhibit O is obviously very similar to the previous slide. This is just a laydown configuration. We drill the wells in an east-west orientation, and you'll notice that fracture has the exact same geometry, just at a slightly different angle. I use 20 degrees west of north because that's the average across our laydown area. And in this particular case, when you go 311 feet of fracture half-length, you'll create 106 feet in the east-west direction and 292 in the north-south direction. And so our setback of 660 will still be adequate, and then from the east-west section line. And then on the far right side of the illustration, you'll see that we'll have 224 feet of space between the tip of the anticipated fracture and the section line on the east side. You will note in the diagram where it says plan 660, it says setback 560. That's a typo. It should say setback 660. So you can see here this will protect all the rights and prevent waste. Again, in this particular case, we would have to come back and ask for wells, as in our previous orders, to drill within those existing setbacks.
Okay. Then, in your expert opinion, you think that the long lateral horizontal wells on a 1,280 acre basis will protect correlative rights and prevent waste?
Yes.
Okay. I have no further questions for Mr. Sayers.
Division?
Thank you. With the board's permission, I'd like to have division staff ask a few questions.
Proceed.
Dustin Doucette for the division. If you could turn to Exhibit N. So on there you have the setback. In some previous matters, people have been reducing that setback to a 560. What is the reasoning for keeping that at 660? Is it to keep orderly development for those additional wells you may come back to ask for, or?
Yeah, so it's a good question. Our development that we're planning to do has not changed in any of these orders. We still have the same pattern, the 660 between wells. We knew that we needed to come back and ask for wells within those setbacks anyways, and so we honestly just felt like it would be more work to change it when we know we're going to need to change it in the future. So why not just do it at that point in time? We don't have any plans to drill wells within the setbacks from day one, and so we'll come back and do it. And also from the paperwork standpoint, as we've heard testimony today, the amount of owners, surface owners, mineral owners that we have to contact. It would reduce the amount of owners that we would have to contact to the west, because we're not changing those setbacks, and so it limited some of the folks that we needed to contact. So I'm not sure the number that it reduced it by, but we'll take up that challenge in the future. So none of our well placement is compromised. None of our future locations are compromised. We'll just come back and ask for it when we plan on drilling it.
Okay. Also on this exhibit, the kind of your east-west half lengths, effective half lengths on there of 220 feet. If you had a vertical well in there that had a similar effective half length, are you concerned about there being some potential interference in those cases?
Well, if you recall, even if it was, we have 330 setbacks from existing wells, so we have to stay away from the verticals 330 right now. But when I look at the overall EUR performance of the vertical wells as it relates to what our performance is, it's minuscule. If there is an impact, I won't say that it won't be zero. But the fact of the matter is that those vertical owners will have the right to participate in the horizontal well. So they'll have rights to participate and get revenues from a royalty standpoint.
So if there is minimal interference, their correlative rights would still be protected?
I believe so.
Okay. And then kind of a similar question on Exhibit O. I mean, it's a little more of an effective half length, 292 feet. Do you still feel their correlative rights would be protected in this case?
I do.
Okay, thank you.
This is Dane Doucette with the division. Mr. Sayers, I just have clarification on Exhibit N and O. Do you have any concern of having the 660-foot setback and planning on drilling right at 660 feet? Doesn't really give you any margin for error of drifting at all?
No, that's a good question. In fact, why don't we go to the staggered pattern exhibit? Exhibit L. And that's what Dane's asking. You can see the shaded area. Those wells are right on the border. And the fact of the matter is I'd consider those undrillable right now for that particular reason. Dane's point is that it gives us no drift to the west. But again, when you look at the wells, we won't drill those wells right now, and so I would consider those as part of coming back and asking for relief and adjusting that setback at that future time.
Okay, thank you.
No further questions for this witness.
Okay, board members? Okay, Carl, we'll start with you.
How long has it taken you to drill one of these wells on the average, including rig up, rig down time?
Yeah, it's a good question. We're probably on average, we've had some issues drilling that were out of the ordinary, but I would tell you we're probably averages 28 to 29 days, right in there.
The oil price has been up a little bit lately. If that market fundamental looks like it's going to stay stronger, Are you contemplating moving in a second rig at this time, or what are your thoughts in that regard?
It's a good question. Probably goes back to the earlier question on getting the oil out of the basin. It's our biggest challenge that I see. We would go get another rig to start developing this, but the Salt Lake market's capable of, say, roughly 90,000 barrels of wax. There's
per day.
I'm sorry.
90,000 barrels per day.
When everything's up and running. The board may have heard that there was a fire recently at one of the refineries in Salt Lake that's cut back production for a short period of time. That'll get fixed, but that's put some pressure on the near-term market. I think that'll get alleviated. But as far as the long-term development, we need to find more solutions than what's available currently in Salt Lake. And so what I would tell you is if there's room, we would accelerate our development.
Thank you.
Any more questions on the left? Go ahead.
You have asked for a very large area to do this request for agency action. How long is it going to take you to drill this area?
Well, as Rick pointed out, we've been, and in fact, in our previous order, as Rick mentioned, I think we got it approved 2 weeks ago and have a rig on it right away. And so we do anticipate drilling. We would like to bring in a second rig when we get some of these long-term issues resolved. But when you think about what we're trying to do, and this goes back to an earlier question, Axia has committed to significant infrastructure, probably in the order of over $15 million just in the movement of gas and water, which have a huge impact on not only on the surface owners by reducing thousands and thousands of truckloads, but why I bring that up is it's very important for us to assess the overall play from a regional sense. How does the west side perform as well as the east side? North side perform as well as the south side. So we're trying to go drill these units on the northern end, on the eastern end, and have an aerial extent of overall performance. Then what we can do is really understand what it's going to take from an infrastructure standpoint. What we don't want to do is go drill one 1280 and drill all the wells there, then move to the next 1280. That wouldn't make any sense. And so what we really try to do is take an overall view, assess the play, in the overall performance of all these zones across the entirety of the play, and that'll help us plan for the infrastructure across it. But as far as drilling inventory, when you look at the amount of units that we have, most likely probably well over 1,000 wells to go drill. It's significant. We can't do it with one rig. And we're not in the business of sitting here and drilling for 80 years. We need to get to a position where we can bring more rigs in and develop in a more timely manner. But to answer your question today in terms of how long would it take, it'd be hard to answer because we're still assessing some of the play up to the north.
What price are you seeing relative to NYMEX for your oil and gas?
It ranges. I would tell you, so you see the NYMEX deck, that's fairly light to where we're at today. But deducts will range anywhere from, I would say as low as, say, $5 and as high as 18 to 20.
Are those deducts relative to the yellow black wax issues, or are there other things that are impacting that?
No, it's a good question. It's all relative to the near-term oversupply that we have relative to what we can produce. And so what that reflects is taking oil out of the Salt Lake market via rail, which is more expensive.
Are those deducts calculated in your rate of return numbers?
They are, yep. And it's important to note that near-term deduct, we're still economic at that point. That's why we're still drilling. And I would also state that I don't believe those will be the long-term deducts. All this happened in a short period of time, and when you need to go find an outlet for oil in a week or two, you can't just magically have rail cars appear. It takes time, and you got to find a willing buyer. Those things take time. And so I'm hopeful that that deduct will decrease with time and planning.
Questions on the right. Mr. Moon.
So the existing vertical wells in that in the request area, do you operate? How many of those do you operate, or how many are not operated by Axia?
Yeah, we just inherited through a purchase that's publicly available through EP. We now have garnered 55 producing wells from EP. That puts our total at around 74 operated wells. That's vertical, and our new horizontal wells. And then you can see here the Quinex has 3 wells, Lynn has 3 vertical wells, and Homeland has 1. So the amount of other wells operated by others is fairly small.
Let's see, one more question. Oh, so we go down one exhibit to Exhibit E. Okay, the two wells that are drilled to the left there, the two that are on the laydown unit, from the existing surface location that you have there, right in the center, can you drill to all 4 drilling locations? Or do you
can I fully develop 4 1280s?
Yeah.
That's a good question. I can tell you that's our next location. We're actually going back there on the same surface to go drill those next 2 units. I would say that would be a challenge. I think we'll probably need more surface locations than that. I'm fairly confident we can do 2 1280s. 4 would be a big challenge. This group, we do have experience with pads upwards of 48 wells per pad, and so we're well versed in that. Because we're focusing on kind of proving up regionally how big this is going to be. We haven't figured out exactly how many that we can go do, but it's probably a roundabout way of saying I don't know.
So which section is your surface location?
It's right in the middle.
But it's in one of the sections, or is it right?
Yeah.
Covering section lines.
Section 27.
For the record, could you use the cursor on your computer to show where Mr. Moon is talking about?
Yeah.
Yeah, right there.
So my question is, can you reach 27? That drilling unit 27 and 28 from that location. How unfeasible does that become?
No, we can reach 27 and 28. I just don't know how far up. Mm-hmm. If we can, we've run models. I know our drilling guy's comfortable with 3,000 feet, and so that would cover just over half that unit. And so, if you took half of each one of those units, it's basically you're back to 2 full 1280s from one surface location.
Okay.
So we'll probably need more in that regard.
But you would be able to reach some locations in all 4 drilling units
from
that location.
That's correct, and
just not.
Yeah, can I use that cursor?
Where do you want to go?
Okay, so in fact, it's moving fast. This is after our current location. We're going to come here and drill this unit here. And we're also going to drill this unit here. So we're going to spud that hopefully in about 3 weeks. We'll move that rig back onto an existing location. Look, it's a great selling point for us is to utilize as much of the existing surface as possible.
Right.
For a variety of different reasons.
Yeah, because you don't have to, drill straight over. I mean,
No.
you're coming from an angle, and so, okay.
Yeah, we're in today's drilling technology, you know, with rotatable steerables and steerable mud motors, we can place these motors to a high degree of accuracy within a foot or two. And so you're right. You don't have to drill straight down. You could kick it back. You could kick it to the side. We consider the production life of the well, knowing that these will eventually go on rod lift. So anytime you have deviated well bores, it's a bit more wear and tear on the rods, and so we try to minimize the amount of curves. But we model that a lot in terms of where do you put the curves, at the bottom, at the top, all those things. So we incorporate the life of the well in making those decisions.
Thank you.
Other questions? Mr. Sayers, we don't often get company presidents here testifying. I'm wondering if you'd be comfortable answering some general market questions for the education of me and the board.
Sure.
Tell us a little bit about the quality of the wells comparative to other parts of the country, and what you see in terms of these pilot projects that we have here in terms of the current market, in terms of production per day.
Sure. When we look at this Uinta Basin, and this goes back to probably 2015, we had been in the basin, had a vertical play, and we came in and assessed this area from a geologic standpoint, and got into the play with a small acquisition of about 20,000 acres. And that's what these first causes were. We came in and drilled some wells, and it was because of the belief of what we felt was how much oil was in place. And we felt like industry hadn't realized, just with a variety of different techniques, that the oil in place, in other words, how much oil we had in these 6 different targets, and maybe 7 or 8 different targets, on a section-by-section basis, competes with any basin in the country, including the Permian Basin. And some people had raised eyebrows when we brought that up, but the reality is our well performance is showing just that. There are very few places in the United States where you can come to a oil resource play where you have 0.85 PSI per foot reservoir pressure. That's almost exactly double a water gradient. And for the drilling folks, it means you have to drill these wells with a 17-pound mud. For reference, a gallon of water weighs 8.33 pounds. It is very difficult to go find highly overpressured oil resource plays in this country. The Permian Basin is the best example. They do in the Delaware Basin, where I think the latest, if I'm not mistaken, the latest rig count is 400. The difference between the Permian and the Uinta is the Permian's over 15 or 16 counties. It's huge in terms of resource. Here, while we don't have the extensive size of the Permian Basin, what we do have is on a section-by-section basis, I think, rock that exceeds anything that I've seen in the Permian Basin. So we have an amazing resource play here. Other quick comparisons, our average oil cut, in other words, when we produce a barrel of oil, you always produce some water. We're 60, probably on average, let's call it 50 to 70% oil cut. Throughout the entire Permian Basin, I bet the average is probably 25 to 30% oil cut. And so we have much more, that's much more efficient. Our gas oil ratios are 750 to 1,000. In the Permian Basin, you see 3,000 to 3,500. That has an impact on overall recovery factor. When you make a lot of gas, the rock likes to flow gas versus oil, and so that's a relative permeability problem. And so I would tell you we're really excited about what we see there. and going to our well performance. You know, we can say that there's all this oil here, but how's our well performance? Well, we've drilled and completed 10 wells to date. We have wells that have been online for nearly a year and a half that are still flowing. We have not put a pumping unit on any of our wells. We control them. We choke them back. We feel that that's pretty important. And so our production rates have been flatter and have been higher than what we anticipated. And so our EURs are by far exceeding our expectations, and we've got a wonderful development here. And by the way, so do other operators. And so when we look at what there is to do in the Uinta Basin from a horizontal standpoint, there is a tremendous amount of upside here, and there's going to be a tremendous amount of drilling. And so you've got, I think in the basin, we're talking 7 to 8 rigs right now, and you got in the Permian 400. But I don't see it going near that size, but could this basin support 10 to 20 rig program? I do. I believe that's very, very reasonable. And so I think it still comes back to we'll exceed what the Salt Lake market capacity is capable of doing. And we're going to need to find an outlet for the oil so we can get these rates up that would have huge impacts on, you know, state lands, BLM lands, BIA lands, fee owners, and so forth. So this play is really as good as any other that I've seen.
Susan, yes, follow-up question?
Yes, thank you. You mentioned gas coming out of these wells. What are you doing with the natural gas?
We're currently selling it. The predominant gatherer out here is Kinder Morgan. And so this gas is very, very rich. 1,000 cubic feet of methane has 1,000 BTUs in it. This gas has about 13 to 1,400 BTUs, and so it has ethane, butanes, propanes, gasolines in it, so it's highly valuable. So we actually gather it and take it to Kinder Morgan, where they process it and pull the liquids out. So we don't flare any of our wells.
Thank you.
Final question. Have you learned anything about this yellow wax in terms of its usability or what the...
Probably more so than I wanted to. It is a very, very unique barrel. I think obviously the biggest challenge that we have with the wax barrel is at 110 to 120 degrees, it's solid. And so I keep forgetting I should have brought some samples in. I mean, it looks like chapstick, and that's essentially what it is. And so it becomes a challenge handling. And so when we produce these wells, we take gas that's provided by Kinder and heat the tanks. So we keep it at about 160 to 180 degrees. The trucks come pick it up, they haul it to Salt Lake, and it stays warm. Those trucks are not heated. In the case where they blow a tire, they're coiled so they can hook steam up and then heat it back up and take the oil off. But operationally, that becomes the challenge. But the barrel itself is one of the most unique barrels in the country because it creates, there's a lot of products that are very, very high-end, very lucrative products that the refiners like to make. Type 3 crude oils, that there's a lot of, it makes a type 3 oil, base oil, which has high performance factors. It's basically what makes Mobil 1 synthetic oil is it doesn't break down it doesn't break down to really, really high temperatures. So that makes it very valuable. So what we need to do as when we look at this basin is find folks that see the value in this oil, and so we can bring it to them, and so we can go and drill more wells and sustain higher levels of production. But the fact of the matter is this is not just a normal West Texas intermediate barrel. There's challenges in operating and handling it, and yet that's offset by a lot of the high value products that this barrel makes.
Thank you very much. I appreciate your taking that extra time. Okay, with that then, we will, does that conclude your
Yes, it
questions
does.
of this witness? Then we'll go to the division for your case in chief.
Thank you. The division supports the request overall. In general, the division supports this sort of overlapping spacing type plan. The division feels like it does a better job of protecting owners' expectations for wells that have already been drilled. The division also likes that the request allows for the potential for future 640s and allows the operator some sort of flexibility because the division feels like that promotes future drilling. So we support the request. I won't say too much again on the briefed issue. I guess we would just encourage the board to find some language that's not misleading in future and specifically in this request, because we really at this point receive APD applications all the time and just don't know what to do with them. So just continue to encourage a different language used there. And I think that's all we've got. Thanks.
Thank you very much. Board members, any additional questions or concerns? Okay, back to you, Mr. Bolda, for summation.
Yes.
Let's admit the exhibits at this time. And what I have is an amendment to the caption on the request for agency action and exhibits A through O. Is that correct?
That's correct.
And if you want to make the motion?
Yeah. I'd like to move for admission of exhibits A through O, inclusive, and the correction to the caption.
Division, any?
No objections.
Board members? Okay, they're so admitted.
Okay. I'll just make one final remark here that I believe the evidence and the testimony presented today satisfies the requirements of the statutes and regulations, and I would ask that the request as submitted be approved and an order issued approving the request.
Thank you very much. Now it's to the board. Board members, we can do two things. We can go and discuss this, or a motion to conclude this matter would also be in order. What would your preference be?
I'd move that we approve this order.
Okay. Is there a second? Okay, the motion has been made and seconded. Any discussion of the motion? Seeing none, the motion before you is to approve the request, Axia's request for agency action as submitted. All in favor say aye.
Aye.
Opposed? Let the record show that that was unanimous. For the purposes of the record, it was published in the notice that we are going to have a meeting and a working lunch to discuss the energy from Environmental Excellence Awards. That will be a public and open meeting just for anyone that happens to be here. And also, before we're concluding, we would ask Axia if you would prepare the order.
Yes,
Mr. Bolda.
we will.
Anything else that we need to do to conclude this case? Seeing none, then a motion to, yes. Mr. Cox, is that correct? Would you come forward, please? And make sure you identify yourself again for the record, and
Morley Cox, address 1199 Cliffside Drive, Logan, Utah 84321. Speaking on behalf of my wife, who is both I'm a surface owner, she's a surface owner, but she's also a royalty owner. We have one request with regard to notice that we'd just like to make formally here. As these various wells come forward to the pooling point, we would simply, as royalty owners, request that the style of notice given to royalty owners as my wife be similar to that was presented in Appendix A under 139-144 with respect to the detail and the readability, so that we have the ability to understand whether you found us, because we know that she is currently paid on about 8 or 9 of the sections. There's about 7 that we know of. She's receiving no payment. We just like to make sure that we can see the detail that you have found to compare with our records, and we'll leave this with you.
Thank you very much. Division, would you look into that general request as to the best way of formatting the notice?
Well, those notices generally come from the operators. They do the forced pooling. Let me.
Yeah, I'm just saying, is there, you know, what's the best? It's kind of a best practices, continuous improvement question, I think, if you deem that to be appropriate.
Yeah, and the focus is to make sure that we don't get caught up in an unnecessary forced pooling situation.
Okay, understood. Okay, a motion to adjourn is now in order.
So moved.
I think the whole board said that. All in favor say aye.
Aye.
Aye. Let the record show that was unanimous, and we are adjourned.
I don't know. Yeah. How I see it, and that's what I was trying to articulate, but then he keeps saying.
Yeah. I think that.